This session is one we have never ever had before, I don't think, in any incident response forum, ransomware attacks and CISO or other personal liability issues, which has become a very important issue. And there's quite a lot of law that's developed over the last year or so. So let's get right to it. We've got another panel of all stars, starting off with John Carlin, who's a partner at Weiss and co-head of their cybersecurity and data protection practice, and probably one of the most highly credentialed and revered cyber lawyers appearing here today. He's held some of the highest ranking, but most under the radar positions at the Department of Justice, including Principal Associate Deputy Attorney General, a job he left less than a year ago, I think, or I'm not sure how long ago, Assistant Attorney General for the National Security Division, which is the highest ranking DOJ national security lawyer. He was also an Assistant U.S. Attorney, a computer hacking and intellectual property attorney, a DOJ trial attorney. He was even Chief of Staff and Senior Counsel to the Director of the FBI. He's the architect of DOJ's current approach to cybersecurity, national security, and corporate criminal enforcement. He's a true patriot and really the Jack Ryan of incident response. So welcome, John.
Thanks, John. After that introduction, I think you've lost all credibility. But
That's not true. Not true. Next up, of course, everyone recognizes Ed McNicholas. What you'll see in his bio is he's data privacy and cybersecurity co-leader at Ropes and Gray, and also that you need a terabyte of space to archive all of his accolades and experience, especially the extraordinary number of notorious litigation matters where he's played the part. But what you might miss is not just the scholarly works he writes on cyber or his role as a law professor at GW, which I think is more than a decade now, teaching a course on cyber and data breaches, nor his expertise on big data analytics, which is critical for understanding how to guard against ransomware attacks. But it's Ed's crisis management skills that set him apart. He's a responder, he's a remediator, he's a rebuilder during IR. He's a multifaceted individual. He's a lead editor of the PLI treatise, Cybersecurity, a Practical Guide to the Law of Cyber Risks. He also sits on the board of directors of the National Homeless Law Center in DC. He's the IR equivalent of Atticus Finch of To Kill a Mockingbird meets Saul Goodman of Better Call Saul. So excited to have someone on your stature, Ed. Welcome.
Thank you.
Next up is Jennifer Beckage, the Joan Jett of incident response, a partner and the founder of Beckage PLLC, a law firm exclusively dedicated to cyber, one of three of those today. And this was not even her first company that she founded. She founded a tech startup that developed internet-based programs and other cutting-edge web technologies for NASA's Kennedy Space Center, to the Buffalo Bills and the Buffalo Sabres. She's now in Austin, Texas. She shows us all how we can set our aspirations, and that not every big incident response icon has to be from some big metropolis. Jennifer's not just an entrepreneur. She's not just a pioneer. She's also an extraordinary, courageous person of epic proportions. When facing the kind of dire cancer diagnosis Jennifer faced a few years back, most of us would crumble and give up, but not Jennifer. She fought and she won a battle that most people, 90% or more, lose. I did a Twitter space with Jen last week, and she talked about her diagnosis and how it makes her a fiercer client advocate. And I believe it. It makes her a more dedicated, trusted advisor and someone who truly believes it when she tells her client, we will get through this, because she gets through things. She's an inspiration, not just to IR professionals, not just to lawyers, to entrepreneurs, but to everyone in the world. It's amazing to be around, Jen. So grateful to have you here, Jen. So grateful. We couldn't thank you enough.
Thank you, John. Flattery will get you everywhere.
Next up is Timothy Howard of Freshfields. Having spent 12 years as an assistant U.S. attorney in the Southern District of New York, including co-chief of the Complex Frauds and Cybercrime Unit, Timothy Howard's practice at Freshfields focuses on white-collar and government regulatory investigations with special attention to cybersecurity, data breaches, crypto fraud. What makes Timothy even more special is not just his conviction of the founder and operator of the Silk Road Darknet website or his prosecution of 18 former National Basketball Association players for defrauding the league's health plan of millions of dollars. He also has a degree in computer science from Georgetown. He is Jack McCoy meets Jimmy Neutron. He's law and order, high tech. Dun, dun. Welcome, Timothy.
Thank you, John.
And next up is David Aaron of Perkins Coie, our final panelist. He focuses, not final of the day, just at this panel, at Perkins Coie on data privacy, cybersecurity, national security. He made his bones as the real deal. His credentials are a mile long. Former Manhattan ADA, trial attorney in the computer crime and intellectual property section, trial attorney in the national security division at DOJ, including a stint as deputy chief of counterintelligence. The awards David has received during his government jobs is a list as long as ransomware variants. A prolific author and commentator. My favorite quote from David came in an article from a month or so ago where David wrote, "It is essential for Americans to have confidence in their government and particularly in their law enforcement and intelligence agencies' commitment to protecting Americans' rights." You gotta love that. He's also taught a course on cyber crime at Roger Williams and currently at Wesleyan, which makes him a cross between Jack Bauer, Ethan Hunt, and Albus Dumbledore. We are thrilled to have him on board with us today. Thanks for being here, David, and I'll leave it over to the moderator for the rest of the show.
Thanks, John.
Great. Thanks. Thanks, John. First, I want to give a shout out to Bruce and John, just a class act. I mean, it's just so great to see how this has grown over the last several years of programs that you put together. The community definitely thanks you for that. I was seeing everyone in the chat, John, try to come up with some combos for you. I don't know if it's John Wick, Jimmy Fallon, Energizer Bunny, Einstein, Abraham Lincoln. You're just all of it all in one, and we really are grateful for you. So today we're going to talk about CISO and leadership responsibility in a data security incident. As an incident response attorney, oftentimes when I'm at events or speaking, I'm usually asked by CISOs, what about my liability in an incident? Can I get in trouble? What am I facing? And we're going to address that today. But I'll say it's difficult when I meet other CISOs at events because usually my firm doesn't represent the CISO individually, just like the panelists here. I mean, usually we're representing an organization. But the whole team, the executives and the leadership team wants to make sure that things are handled properly. So still from the organization, we just want to know, what can we do? How can we protect our company? How can we protect our team? So today we just won't talk about CISOs. We'll talk about other leadership as well, but you'll see us focus a lot on the CISO role. We're going to first talk about how the CISO and leadership gets involved in an incident and why are there concerns? You know, how did this all start? We'll kind of give you a little crash course on some of the case law out there from a lawyer's point of view. And then we'll discuss some of the agencies and regulators and their take on individual liability. And then what's next? What does the future hold? How can we better protect ourselves going forward? So first, you know, let's talk a little bit about the CISO and role of leadership in an incident. You know, I've been in cases, and I'm curious to hear kind of from the panel, you know, where the CISO, as soon as this happens, right? I've seen near heart attacks, physical expressions of, you know, the stress that this causes. What is sort of the responsibility of a CISO and leadership in an incident? And maybe Ed, I'll start with you on that question.
Sure. And no doubt it can be extremely stressful. I had one CISO who, and this will perhaps date me, but he just went into the smoking room in our office and just kept smoking. And we just like, okay, we need to talk to you about what's going on quickly. We had to send in an associate and smoke with him to talk to him. It's very stressful. And I think a lot of CISOs are concerned primarily about losing their job or some sort of comp reduction or something like that, not getting a bonus. And generally, that's what they should be concerned about. Normally, the baseline duties that a lot of the law is built on are the fiduciary duties. Now, those go for directors and officers, and it's a duty of loyalty and a duty of care. And the duty of care is to make sure that you are relatively well informed, you're exercising reasonable judgment, duty of loyalty that you're acting in the best interest of the company. Now, CISOs, like privacy officers, are often not officers. Yes, there's an O in their title, but it's kind of a small O. They're not Delaware statutory officers. And you could be a full officer as a CISO, but generally you're not. And so if you're just an employee, it varies by state, but you usually have a fairly limited version of fiduciary duties. Basically, you just have a duty of loyalty, that you cannot be, as it's called, a faithless servant, that you have to work at the direction of your company and in their best interest. You cannot go off on a frolicking detour. And so the standards of care and loyalty that are most of the case law, frankly, is built on are really for directors and officers. Employees generally just have to do what they're told as long as they're acting, in the best interest, reasonable best interest of their company, and even trying to. Generally, even if they make a mistake, they're still covered, and they don't have other concerns. And so it really is surprising that we are talking about CISO liability, but here we are.
Any other comments?
So just add, well, first at the kinder and gentler Paul Weiss, for the record, we never direct associates to smoke, no matter what the situation is. Ed, I don't know what's going on over there. But then in terms of the
associate did smoke beforehand. I'll make a point of order there.
Well, that is an important caveat. But I would say in terms of the CISOs and how to protect yourself, and I recognize we're a group of lawyers, so maybe this will sound lawyer centric, but I do think one mistake I've seen sometimes is in the interests of sometimes I think independence, sometimes trying to show that they can manage problems on their own, that there's a failure to bring legal in early. And one of the most notorious cases where someone in a chief security officer was prosecuted, it was an instance where the person in legal reported directly to the security officer and not to a separate legal chain. But I think one of the ways you can protect yourself is actually bringing lawyers in, getting their advice, and then even if people ultimately disagree with the decision that's made, it's one where you properly relied on counsel. So that's one issue to consider. And secondly, and relatedly, it's the briefing up on risk. And so I know everyone on this group, with our experience, believes strongly in the adage that there is no internet system that's safe from a dedicated adversary who wants to get in. If you're connected to the internet, you're vulnerable. And that's true for us in our government experience, as has been amply demonstrated by departments ranging from justice to those in the intelligence community, to the Homeland Security, to the SEC, most recently, have all been hacked, along with private companies. So it's not a failure if there's an intrusion, and it's also not a failure that you're going to have risks that you can't fully mitigate. So, thinking through as you're describing your plan realistically, the attempts you're making to mitigate the risk, but also that the risk remains, and doing so in advance of an incident can help protect you later.
Yeah, and I think at the end of the day, though, if you're a CISO, ultimately, a lot of people in the organization, maybe externally, will think of you as sort of the fall person, right? This was your domain, your responsibility, and it's really not that way, right? It's a team effort, and everyone's got to respond, and we'll just prepare before an incident, but also respond if there is one. Tim, could you talk a little bit about maybe some of the pitfalls that you see in an incident?
And I think happy to, and I think it works off a little bit of what John was talking about. And there's fear amongst, and I'm going to broaden it a little bit from the CISO to the security staff and personnel of what are the consequences of something bad happening. When, as John said, it's almost inevitable that something will happen. It's how you deal with it. And so now that today we're going to be talking about certain cases in which various regulators have gone after individuals individually. We've seen incidents where there's a lot of finger pointing internally, whether it's the CISO or whether it's staff, and you really need to encourage kind of this team effort to kind of respond, contain, exclude the adversary, where you're dealing with just the facts of the here and now to deal with it. There's a time to deal with the root cause. There's a time for lessons learned. And regulators may ask those questions when you're presenting them. But in the first 24, 40 hours, 8 hours of the incident, folks need to be careful not to be blaming someone else for not applying the patch properly, or not investing in a certain type of software protective measure that they recommended. All of those things can be used against the CISO or the company. And a couple of the examples I think we'll talk about later, DOJ and SEC have relied upon statements of lower level employees to kind of, depict deficiencies that are not helpful.
No, that's a really good point. And I think for a lot of people that are joining today, they may not even have a CISO. They may have a virtual CISO or a fractional CISO. And so there could be different liability, right? We're not even maybe talking about employee. Maybe this is a CISO you have because of a contract, right? So now they have contractual duties that they owe. What though, Tim, and maybe David as well, what are some of those unique challenges that you see for CISOs? When you think about the role of them in an incident, they just have they're supposed to be in control of everything, but in an incident, suddenly they don't have a control over everything because, John, as you mentioned, right now we've got lawyers involved and we've got other third parties that are helping to direct, containment and remediation. Any thoughts on some of the very specific challenges they face?
I've talked to some CISOs recently who feel as though words may be put in their mouths, or they may feel pressure to kind of make certain statements or draw certain conclusions. And when we talk about kind of willingness to speak up and kind of make sure that statements are accurate, make sure the record is clean, they sometimes feel like their head's going to get taken off. I wouldn't say I see that everywhere, and it's also not unique to CISOs, but they don't feel always that kind of empowerment, that support to kind of play it down the middle. And they may be misperceiving that pressure, right? I'm not saying that pressure is actually always there, but they do feel, I think this is part of that self-protective pressure on them. They do feel that there's a message they're supposed to be giving.
Jennifer, I think you hit the nail on the head earlier when you said that it was a team sport, and that I often find that there's a misapprehension pre-incident. If folks haven't tabletopped or war gamed what it'll be like, or haven't lived through one before, that you just get briefed by your CISO and your security chain, and they're going to handle it. But in reality, when there's in a decent sized incident, the CISO's job is going to be focused on protecting the system, remediating the system, getting the bad guy out. A lot of the critical business risk decisions, who do we tell, what do we say, when do we say it, what decisions do we want to make on risk in terms of taking a system offline for a period of time to do forensics versus risking the fact that the incident might become more severe, but we don't want to take the certain business interruption. All those decisions are really made by the executives as a team. And if they don't practice that, they end up confronting those decisions for the first time in the middle of a crisis. And so that's an area as well I think you can focus on tabletop or wargaming exercises that really emphasize the decisions that everyone makes other than the CISO in a real incident.
No, preparedness is key. And with that, as David mentioned, this is sometimes, in an incident, they want to do things and they feel like words are being put in their mouth. I started off in technology and then became a lawyer, and, technologists, they're used to saying everything and documenting everything, right? And suddenly now we're not supposed to say anything. Don't put anything in writing. So that preparedness, I think, is really important. And I think, as we talk about preparedness, one way to help prepare yourself is to understand what the law and the case law looks like out there. So I'd like to pivot now just to talk about some hot cases, that really shine the light on what could be potential CISO liability and executive liability. The first one's the Uber case. So Tim, could you talk a little bit about the Uber decision and what are some of the lessons learned?
Very happy to. And so, I mean, Uber is a case to consider, but I think in the broader scheme, the issue is much narrower. The case is really about a cover up rather than other kinds of deficiencies. Here, Joe Sullivan was the chief security officer of Uber, and Uber had experienced a 2014 breach where driver personal information had been exposed. And so the crux of the DOJ case surrounds interactions with the Federal Trade Commission that were investigating the 2014 breach. And during that investigation, Uber suffered yet another breach in 2016. And so what happened, he ultimately gets charged with obstructing the FTC and misprison of a felony. That's a very rarely charged federal statute relating to really the cover up of the 2016 breach. And so there was a lack of disclosure in depositions that FTC took regarding other incidents, and FTC, as they frequently do, issued very broad document requests for any incidents up to the current date relating to the exposure of driver information, which they did not disclose. There was plenty of unhelpful internal communications by members on the security staff, including a reference to Sullivan lying during his deposition and the idea that they have to keep this very hush-hush, and even another statement that kind of indicated that the 2016 investigation does not exist. And then probably worst of all for the facts for Joe Sullivan was how they resolved it with the hackers that were extorting the company. So Uber had a bug bounty program, and what they did, according to the DOJ case, was they arranged to pay off the hacker through the bug bounty program, increasing the limits of how much they'd pay, which isn't really the big issue. The big issue is they got the hackers to lie as part of an NDA and basically sign off on this notion that they never touched personal information, which Joe Sullivan knew to be false. So this case is really about the cover-up, and is not as, I think, scary for executives when you really think about it as the SolarWinds case, which we'll talk about in a minute. And, just really goes to some basic kind of things that John mentioned, like bringing in legal early when you have an incident to consult with them about what you're saying to the regulators is important. Governance controls, including around bug bounty programs and how you run those, just to make sure they're tight. And, when I was at DOJ, we frequently saw a lot of situations where you'd have black hat hackers trying to squeeze in through the bug bounty program as kind of a light extortion. Things to kind of think through when you have that program, how you're going to deal with those kind of situations. And then finally, the idea of cooperating with law enforcement, how that could be leveraged to the company's advantage. And, the press release from FBI surrounding this case kind of hints at, maybe if they came and talked to us and cooperated in the 2016 breach, things might have been different. So, at least if that had happened, obviously they needed to do the right thing vis-a-vis the FTC that was actively investigating them. But there couldn't have been a suggestion that they were trying to hide it from the federal government altogether. Had there, after the fact, they could have pointed to the idea that they were proactively cooperating with law enforcement on a criminal incident.
No, that's great. Thanks for that. And, since you brought up SolarWinds, maybe you can give a little bit of overview of SolarWinds, and then Ed, I'd be interested in your thoughts on, how the two cases maybe differ and some lessons learned from each of those.
Yeah. So at a high level, I don't want to speak too much. I want to get over to Ed as soon as we can. SEC recently charged SolarWinds and their CISO, Timothy Brown, in his individual capacity related to disclosures surrounding the company's cybersecurity posture and disclosures related to a 2020 attack that's been attributed by the U.S. government to Russian intelligence. And so the case, despite, statements in their registration set and their risk factors regarding the fact that the company is vulnerable, as every company is, to cyber attacks, despite best efforts, despite robust defensive measures, SEC dinged them in multiple ways in a very aggressive fashion, including for things on their security statement on their website regarding the state of the security. They hit them for the 8th. They disclosed the incident in an 8K shortly after the incident. And this is now before the recently enacted SEC rule that would require it of every public company. But the SEC dinged them for the quality of that disclosure, including the notion that after that they were still investigating whether certain customers had been impacted. Now, they issued an amended 4K not too long afterwards once they confirmed that, but SEC dings them for not tying the customers definitively in that first 8K. So there's a wide range of very aggressive positions the SEC is taking in this case.
Great, thanks, Ed.
But and I do think that the SEC has been particularly aggressive. I have a slight bias. I still represent the former CEO of SolarWinds, the person who was the CEO at the time of the attack. He was not charged as part of this, but and I'm not speaking for him today, just speaking kind of academically myself. But one of the odd things about it is you mentioned, say, Uber, if they had gone in and talked to government, things might have gone better for them. In the SolarWinds case, SolarWinds found out on a Saturday morning and ran into the arms of the FBI and CISA, worked very closely together with them. And then on Monday morning, first possible day they could have put out an 8K, stopped the trading of the stock at the beginning of the day, waited until the 8K was ready, and issued the 8K. So there was not 1 minute of window where the stock was trading that the 8K was not available. And so despite having run to government, worked very closely with CISO, very closely with the FBI, and put out the notice as soon as possible, they still got dinged. And this is particularly amazing given that this has been formally attributed to the Russians, and it was a state-sponsored attack. So, is the standard of care really that any company is supposed to be able to stop a state-sponsored attack? The Uber case, there was a lot of, basic deception there. People were doing things that were morally wrong. And probably a reasonable person would have felt they were doing things that were morally wrong in the Uber case. SolarWinds is very different in that this is a case where it was a big attack and we had a motivated regulator and they wanted to go after somebody, which is, it's a very troubling case, particularly given this notion that they went after Tim Brown, who is a small O officer, just a CISO. He wasn't even, at the time, he was actually a director, a senior director of cybersecurity. And they said he was aware of, I'm quoting from their press release, he was aware of cybersecurity risk and vulnerabilities, but failed to resolve the issues or at times sufficiently raised them within the company. But I bet if you went through any CISO's mailbox, you would see it chock full of places where they failed to resolve issues. Like my wife, when she sends me something up at the house, it is always that there's something wrong with the house. I mean, that's being a CISO. You're supposed to maintain the security, and your email box is therefore full of things that are not good with security. So I'll get off my little high horse here, but I think SolarWinds and Uber, vastly different cases, and people are rightly troubled by SolarWinds.
What about the communications in that case? Prior statements made, notice of different things. I mean, all of this becomes, like you said, it is very troubling. If I'm a CISO listening in right now, I'm terrified. And we already have such a market where we don't have enough security professionals. Does this make professionals not want to go into cybersecurity because of the fear of individual liability? I mean, as lawyers, right, we're always looking at the reasonableness standard. Ed, I think you mentioned that yourself, right? I mean, what's reasonable?
Yeah. One of the things that Brown particularly they put back on him is he had a blog on cybersecurity best practices. Mm-hmm. And a lot of CISOs, the whole culture of IT security is to talk about things, trade information. Hey, we're seeing somebody getting across this. What about that? What about this? And they're technical problems. You have to discuss them. And if every time you're writing a blog entry on what you think is an esoteric topic that no one cares about, and you're afraid that, wait, maybe, 4 years from now, the SEC is going to be thinking that this was a problem that I didn't raise, you're not going to be doing nearly as much in terms of blogs and communication, and that will hurt cybersecurity.
Well, it's, I won't date anyone on the call, but I mean, just the times are different now, right? The way to be able to publish information is different from 20 years ago. And all of these things can come back to bite you. Just generally for anyone, what about liability pitfalls for CISOs of governmental entities? Is that different? We've got some questions coming in. Or is a CISO?
I think some of the same practical steps that we've been discussing can help you in a government setting, but it is definitely different. Some of the liability that we're just discussing is really unique to the context of a publicly, the SEC action is unique to the context of a publicly traded company. For the federal government CISO, your liability may come from, you may have requirements and legal liability if a statement that you make is false to someone investigating inside of the government, which is going to happen on incidents inside the government on a regular basis. And of course, for most government CISOs, your toolkit's more limited than it is in the private sector. That said, I think there's new programs designed to have departments with expertise like CISA be able to provide assistance to CISOs in other government department or agencies. But the don't say stupid stuff at the beginning of an incident kind of practice pointer is, I think, an important one, whether you're in government or in private. And I always recommend it's the time to, you'll have your training about that when you're in a setting like this, and it's easy to say and spot the issue. But the key is to have a moment, even though you're under such pressure and things are moving so quickly, at the beginning of an actual incident where you get folks on the phone or communicating together. And that's when you give a reminder that jokes that seem funny on Slack now do not seem funny 2 years later when you're sitting in a deposition. So be careful and you don't want to chill, be careful to stick to the facts, leave opinion and jokes for later, to have that can make a real difference, I think, in the way the communications. I'm just going to jump on the horse that Ed was riding, but and I think Jennifer, you said as well that I share the concern that this case is ill-advised. And disclaimer, I represented the company that discovered the Russian intelligence had hacked through SolarWinds into their system, so Mandiant at the time. But in my government hat, and I know I've had the pleasure of working with both Tim and David in government, in the national security space and the FBI space, there's a huge press right now, and it's the entire Justice Department strategy, along with other intelligence agencies, to encourage the private sector officials, particularly CISOs, to voluntarily share information, because much of the infrastructure is held in private sector hands. A lot of the disclosures are not required. And having a case that chills speech and says, your honest and early appraisal, even if it turns out to be wrong later, can be used against you and used against you personally, I think actually makes us less safe as a country. And it's particularly unfortunate that they picked a case to do it that involved one of the most sophisticated foreign adversary intelligence services, not even a routine criminal group.
We're getting a lot of questions in, and John, you mentioned the DOJ. I'd like to wrap up some of the case law discussion because we've only got so much time allotted. I know we could talk for hours about this. We could talk about Yahoo and Equifax and other cases, but we're getting definitely a lot of questions about, from CISOs, what do I do to protect myself? What can we do, especially when the business doesn't. I've been telling them I needed the budget to do this. I didn't get it. Now we have an incident, and now I'm supposed to. Those messages are already out there when I've advised them of this risk, and now it's happened. Right? We've worked so hard to bring leadership together, technical, legal, executives, right, all into the same room, and it's almost like we're starting to pull away from each other a little bit, and we don't want that to happen because that teamwork is so important in an incident. But John, to go back to the DOJ, and Tim, I'd love to get your insight on this. What are we seeing from the DOJ as it relates to individual liability?
I think there's two trends at DOJ. So one is, and you will never hear this in another area, but the lead FBI official over cyber, assistant director for cyber division, said, quote, "I want my agents to be the Ritz-Carlton of customer service when it comes to victim referrals." So they are making a concerted effort to treat victims as victims, and that the bad guys are the criminal groups or the nation states overseas, not the companies who've been hacked. And you've heard that same message echoed at the highest levels of the Justice Department leadership. So on the one hand, you have that trend at the Justice Department, and they also pushed hard, even with the new SEC rule, to have an exception where if there is a national security or public safety circumstance, that the Attorney General could toll the otherwise mandatory disclosure through an 8K after you've reached a conclusion of materiality. That said, and I think you got some questions on the federal government contracting side, they also have a civil fraud enforcement initiative that are looking for false statements in the contracting. So it's a False Claims Act initiative, so that if you do not disclose in areas where you're federally contracting, that they're actually moving more aggressively in the enforcement, which is a little bit counter to what they're doing on the criminal and national security side of the head. But bottom line is, I think justice is probably one, if you're thinking about where to share, it's safer to share with the FBI or others where they're not going to be looking to use it against you. And then there are other regulators, SEC, states, Attorney General, FTC, that are on the, they're going with the stick rather than the carrot approach. And a few other thoughts.
Yeah, I mean, I agree largely with you, and the Ritz-Carlton service, I've actually been impressed on this side of the world where I'm advising companies and trying to explain to them why cooperating with law enforcement is in their advantage and why they should do it beyond just doing the right thing. I've been very happy that I haven't been burned by FBI and DOJ. They've given the Ritz-Carlton treatment, and my clients have been happy with that. So as you said, there's only, I think, very narrow caveats in terms of liability. One is the Civil Cyber Fraud Initiative. And I know one thing that DOJ has been starting to do with various agencies is tightening up contracting language in new and renewed contracts to, really create additional hooks to go after companies in the sense, and, it's a False Claims Act situation. So you've got to be concerned with whistleblowers and aggrieved IT employees who, may even exaggerate or conflate things that will still cause trouble for the company to respond to these things. The other thing that I just wonder, and I'm keeping in mind, is this whole pressure the DOJ has had on ephemeral messaging and record retention. And so that could be an issue. I think companies need to think through before an incident if regular communication channels cannot be used, and there's many legitimate reasons in an incident to do that. If you can't rule out the threat actor's been excluded, like how are folks going to communicate? A, for the logistical part, to make sure that the team members can communicate with each other. But second, think through how are those communications being retained and preserved in case a regulator asks later, and not be sloppy there. And I guess the final thing is the Uber thing. Just don't lie and obstruct ongoing investigations, right? That's another hook. But generally speaking, DOJ isn't the biggest threat in this space to individuals.
So someone mentioned the SEC. Does the SEC have a general policy? And I dare bring up the 4-day rule. Thoughts on that?
And the DOJ does, the SEC does have a policy in looking at charging that they will look at executives. Now, normally they've looked at directors and officers. Going all the way down to the CISO seems to be arguably out of step with their own policy, but it is, they have looked at individual responsibility, and you just haven't seen that. Like the Federal Trade Commission, which has been a traditional enforcer that we've all dealt with as state attorney generals. Yes, they can bring actions against individuals. They could include officers in their actions, but generally they've looked at that and said, no, this is a hack. These people are a victim of a crime. Maybe we're going to go after them because they didn't have adequate security, but they're going to go after the company corporately and not on an individual basis. One thing we do see that is going to be, I think, more of a trend now is that in light of the SEC's environment they're creating is to have a special cybersecurity review committee of the board of directors where you have an independent law firm who doesn't do any work with the company come in on behalf of the board of directors at the board of directors and conduct an independent review of the cybersecurity incident I did one of those for Yahoo. Other folks have done those in other circumstances, but it is something where I think that trend is going to be coming more and more, where the board of directors will have to step back and do an independent review of the circumstance to make sure they don't get sued by the SEC.
What about, taking it to the state level? I've always been a big fan of the New York State DFS cybersecurity regulation. New York State really was the first state to have a big security regulation. I think it's concise and plain language, and it was really the first statute in the United States that really talked about the responsibilities of a CISO. I know there's been some amendments. Tim, I don't know if you've got, some thoughts on how this plays into everything, especially at the state level.
Yeah, happy to. And so, some of the critiques, about the SolarWinds cases, about the fact that you're going after the CISO individually, but there's a lack of kind of delineation in the SEC guidance as to what the responsibilities are specifically. And in fact, there was, a lot of proposed language in the new rule that just came out that was kind of backtracked, and now SEC is kind of regulating by enforcement rather than this rulemaking process they just engaged in, right? DFS is a lot more clear in terms of various CISO responsibilities, and the new amendments make it even clearer. And actually, CISOs need to be aware of it because it does create kind of a beachhead of potential liability in terms of certifications that they're required to make on an annual basis. That was always there. You had to certify compliance with Part 500, but they've kind of expanded the rule to explain, well, you've got to certify if you're in compliance, or indicate specifically in a filing, you got to file one way or the other, or describe which parts of 500 you're not currently in compliance with, and what is your timeline and strategy for remediating them. So anytime, you're making disclosure the CISO is signing, you're opening up potential liability if those are found to be false statements. So, but DFS is being significantly more clear than the SEC about what the lines and responsibilities are, which I think is at least helpful in that regard, so you can kind of think and organize your activity around that.
Yeah, I mean, if you're a CISO and you're trying to understand what your role and responsibilities are, I think it's a great place to look, right? The reporting to the board, having a program that you get that buy-in, all of those communications at all levels. I mean, technology is not an afterthought. This is part of every organization, and they're leaders in this in all organizations. So we have to work together to make sure that we understand what, from a governance perspective, from a transparency perspective, what everybody's roles and responsibilities are. I guess before we move on to some other topics, anything else that we want to talk about as it pertains to the 4-day rule? I mean, I can imagine, the SEC became effective mid-December, has this new, 4-day reporting requirement. Some earlier sessions talked about it, but specifically as it relates to CISOs and leadership, imagine the pressure, right? I mean, granted, lots of organizations are subject to a lot of different statutes and laws that require, very quick time frames, 72-hour reporting and things like that. But, this has garnered a lot of attention. And how can someone determine what is a material cybersecurity event, within 4 days? How does that play into all of this?
There, I think, you should think about think of it as a governance issue, and it requires a finding of materiality. You're the CISO. You're not the person best situated in the company to determine whether something is material, and you don't make materiality judgments in other areas. I think your role is to make sure that the right officials in the company who would otherwise be responsible for disclosure are armed with the information that at the time. And then, to me, the key thing is, I'm sure, and we've all seen this a little bit, especially when things are moving quickly, is then remembering to document that so that it's clear what you knew at the time. And the fact is, early in an incident, what you knew at the time may not be very much. And so that's the tableau in which the committee is originally making a call that, hey, at this point, it's not material, and we're going to continue to look and be informed as the incident progresses. And I think spelling out the process by which you rank the severity of the incident and then provide that information to a disclosure committee, and then the disclosure committee documents why they decided at that time it was or wasn't material. will be key, and practically, because to your point, Jennifer, I mean, if they didn't require you to do the materiality analysis, trying to do this in 4 days would be ridiculous. And I think, as Ed mentioned earlier, and then you hold people responsible for what they say, that it's not fully complete. That would be a standard that I don't think folks could realistically meet.
Well, David, I think what John's talking about too is, incident response preparedness. And, the CISO could have a huge voice in what might be material to the organization, really understanding the impact on systems and things like that. How does this all feed into incident response preparedness, or any other comments on the new 4-day rule?
Well, when it comes to the materiality determination, right, that's not a technical decision. That's not just about IT and just about what's going on the cyber side. It has to do with holistically the impact on the business. So what the CISO has to do is like John said, assemble the right stakeholders, and that might differ from incident to incident, and see what's the downstream impact on the company. Is it having a material impact on the company writ large, such that it would inform an investor's decision, not limited to informing an IT worker's decision, right? So that's what the CISO needs to do, is make sure that this is being staffed correctly, documenting that there is progress towards a materiality determination, that no one's dragging their feet to stop that 4-day clock from starting. But the CISO shouldn't accept responsibility for making that decision as part of the IR plan.
Great. Anything else generally on incident response preparedness, David, as it relates, to individual liability? How can the team huddle up together and kind of protect each other in the organization?
I mean, just having the attitude that they should do that is important, right? Making sure that there is no message, either expressly or implicitly communicated, that the level of the quality of security or the nature of security should be overstated, or that the impact of an incident should be understated. That has to be clear. That's not expected of anybody, and that people speaking truth and playing it down the middle will be supported. When their statements have to be incorporated into public communications. I think keeping everyone on that page when the incident actually happens will only occur if they've drilled that, and if that's been kind of made clear from the top down.
Ed?
I do think it's important to maintain clear communication along the way, that you have to have periodic reporting with the executives, with the board of directors, with the lawyers, so that the lawyers have a sense of the reporting and that discussion, so that you have a good communication flow, so that when you are in a stressful situation, you can still communicate effectively. You can do that through tabletops, but I think also having regular briefings is just crucial. And that also will provide that paper trail of, listen, we were jointly solving these 10 problems. The CFO said we could only fix 4 of them. Great, reasonable decision. We're going to document we're fixing these 4, putting these off into the future. I think that's the way a CISO can sleep at night, and talk to the company's insurance broker and make sure you have coverage. CISOs are probably not covered under a normal D&O policy, but they probably have other coverage unless it's a small company. But it's fair to check that.
We've got a couple of minutes left, and Ed, you did a nice kind of couple takeaways for the group, right? They've heard about this case law. They've heard about, the agencies and law enforcement and communications and incident response preparedness. Tim, John, David, I want to give each of you an opportunity as we're wrapping up here. If I'm listening in, I'm an executive in an organization, I'm the CISO, I heard all this. What do I need to do today? What's something that I can implement today to make a difference, make a change for our organization, so that we don't become one of these case laws or cases that we're talking about at the next incident response ransomware forum next year? Tim?
So, I think this is kind of piggybacking a little bit on what we're talking about now, but the idea of kind of thinking through in advance, planning through the tabletop exercise, through all these things, that serves a lot of purposes that we've met in some of these cases. One is you get accustomed to bringing in legal early, right? And you avoid some of the pitfalls there when they're not involved, like we see in the Uber case. Also, building a collaborative atmosphere that you're in this together, right? To kind of tamp down this kind of tendency to cast blame. This is a crisis situation. When you get the facts, when you get the third actor offer system, it's not about pointing fingers and putting bad things in writing, right, that are not helpful. but build through exercise and through repetition, bringing different stakeholders together. You can kind of build that culture and environment that's going to be more productive than not having it.
Great, David.
I'd say use that collaborative structure to make sure that your public statements are not making things sound better than they are. You've got to make sure that people are pressing and challenging on draft public statements and picking them apart to make sure that you're not saying anything that inflates security or soft pedals impact.
John?
Echo the above, and we'll add know your lawyer. Hopefully, you have someone inside the company who understands you and understands your business, and that you trust. And then second, related to what we've been saying today, is on the prep, you can pre-write a lot of this, so you won't know the specific facts, but you can have these are the key 6-7 factors we need to consider as to whether something's material, pre-written. So we considered these 7 factors. You can have holding statements pre-written, and that saves a lot of it. Can save a lot of time in the event. And then the finally, but this is really echoing what everyone says on the one team, one fight approach, is making sure that not only do you understand that, but the rest of your company, and that you know the folks who are coming in outside, so you've all had a chance and understand that this is not the CISO's job. This is the whole company's job on cybersecurity, and well, the CISO plays a critical part.
Agreed. Thanks, Bruce. You're here.
I'm here. Thank you, Jennifer. Great job moderating. And David, John, Tim, and Ed, thank you so much for your insights today. It's a great panel. Thank you very much.